Okay, welcome everyone. We are at 10 o'clock, so I'm going to go ahead and get started. Okay, so now everybody should see my slide there, the title slide. So today we're here to talk about, so I titled it Actions Not Words, Addressing Illegal and Harmful Behavior Using Existing Laws. And as I was working on this, I thought, well, there's a couple different ways we could go with this. One way is, we could just sit here and talk and I could go through, well, this law does this and this law does that, but that didn't seem to be that exciting. I do have a sheet that I will send along with the slides that is kind of a grid that has a list of specific behaviors and what law in Michigan could address that, from a criminal perspective or a civil perspective. But we're going to talk a little bit more about kind of the stuff surrounding this. So not just specific, this law will do this and this law will do that, because I don't think that would make a very exciting, interesting webinar. So as you all know, my name is Clare Membiela. I am the library law consultant here at the Library of Michigan. Here is my contact info. If you email me, that's probably the quickest way to get a hold of me, because I do check emails constantly. I do have a high volume of requests, so I tend to address them in the order in which they are given to me. So if you feel like it's taking too long, or if you're worried that I forgot or didn't see it, just do not hesitate to nudge me. I do not take offense, and I will, then get right back to you. Okay, here is my disclaimer. Just because we are going to be discussing legal information, I just need to make sure that everybody understands that we're just providing information today. And if you have any specific issue, you really want to talk to your attorney. And we're going to be talking about that as well. You're going to hear that mentioned a few different times in this presentation. So what we are going to talk about today is, due to, as many of you have been experiencing or everyone has been reading about, there's all kinds of things going on at public libraries right now. But there's also, that's not necessarily new. The intensity of some of these things have maybe gotten a little bit worse than usual, and the idea of book banning and that's kind of a little bit of a new thing for a lot of librarians. But this idea of incidents at libraries and this idea of libraries as a place where sometimes strange or disconcerting things occur is not necessarily new. I've worked in libraries for 30 years. I've worked in a variety of types of libraries. Almost every library I've worked in has been open to the public. And as you all know, we all have stories, right? We all have some really interesting stories. So, even though the idea of this came about because of everything going on with the book banning and stuff, this is a topic that is not something that I think is that unusual to many librarians. So we're going to talk about your regulatory authority. That is, what is your authority to actually have rules and policies, and also to enforce those policies and rules, because, those are two different things. You can have a policy, but then the enforcement of that policy can sometimes be a completely different thing. We're going to talk about the types of violations that exist. And some of those violations are routine, violations, the more minor violations, and some of them are more serious. We also have the concept of someone who makes a mistake once versus people who consistently make mistakes. And then also, we get down to, so what are your legal options as a government entity with regards to both, civil matters and criminal matters. So as I mentioned, a lot of what inspired this was these inflammatory issues that are going on in the library. And inflammatory issues can take a lot of kind of colors, right? So you can have organizational inflammatory issues, which could be things like employment problems, or it could be board issues. you can have, or they could even be municipal issues, right? Depending on your establishment and your circumstances. You have historical and community issues. Now, there are many libraries in Michigan that have huge histories, right? Because libraries have been around in Michigan longer than in almost any other state. So there is some really long history, and sometimes history is not always congenial, right? So you can have some pretty deeply set resentments between townships and between cities and between a municipality and its library, or between there could have been an incident in a community where the library was involved, and that created some scars in the community on both sides. So sometimes you have inherent issues that kind of already have inflammatory things simmering in the bottom, right? So that means that any additional things that come along can actually be exasperated by this kind of underlying resentment or underlying bad feelings. It's kind of like a family, right? So if you have a family where there's been long an incident or something that occurred in long ago, and people are still kind of a little bit mad about it, or there's still stories about it, when something else comes along, that can sometimes make this the new one worse, right? Even if the new incident is minor, it can seem like it's a lot worse. Then, of course, we have political issues, which is some of what is inspiring some of the issues going on now. These are also not new, but they have gotten exasperated by a combination of things, including technology and social media, and also just the general kind of vibe in the communities now, right? We've all been through a really harrowing pandemic. There's been a lot of financial and socioeconomic issues that have been around. There's a lot of cultural upheaval. And so, again, all of that kind of mixes together. So you drop something else in the mix, like a political divide, and again, that can exasperate things and make things that much worse. So sometimes it can help the whole process of this idea behind, what kind of actions should the library take when things occur, to understand the basis of some of these things, right? So you have a patron that comes in that, makes a threat, right? And the threat, you make a decision. Is this a actionable threat? Is it a legitimate threat? Or is it, rantings, right? And again, understanding some of the underpinnings of things that are going on in your community, both the history of your community, the current demographics of your community, the political makeup of your community, all of these things together can help you make a decision on those individual factors, right? So is this a serious threat? Is this someone blowing off steam, right? It's not always, this is not an exact science, right? But these are also some other information that helps inform you, as and when I say you, I mean library director or library board member, library staff member, in terms of the kind of decisions you have to make in your job, and the kind of policies that you set. So it's always good to have that background for many reasons, but also when we're discussing things like enforcement of policies, and how to act when certain actions occur in the library. So let's talk a minute about what your regulatory authority is in the library in terms of both policy and enforcement. So most of you have heard this. We really can't talk about regulatory authority or policy without talking about the fact that the library is a government entity. The library is answerable to the Constitution of the United States and of Michigan. It is answerable to and must protect the First Amendment. So under constitutional law, and particularly the First Amendment, when you talk about regulation, right? So when you look at constitutional rights, and then you talk about the regulation of those rights or the limiting of those rights, the courts have decided that government entities that have this responsibility, they break into these three possible forums, right? So you have public forums, which is the most protected. A public forum is the forum where people can say anything. So speech is completely open. Things like the sidewalk of the town or the street where people can protest. It is very difficult to limit in the public forum. Right, it can be done, but it's very basically it's public safety, and there's certain criteria that covers whether or not you can limit within the public forum. Then you have limited public forums. So limited public forum is that area where it exists for a particular purpose, right? So things like the post office and the maybe different agencies in the state and public libraries. Because they are set up for a particular purpose, right? Public libraries' purpose is to enable people to exercise their right to information, and so that's their duty and their purpose is to provide access to information. So as a limited public forum, you're permitted to provide some regulation and restriction. And then as a non-public forum, that's the most restrictive. A non-public forum would be something where essentially the public has no real voice. So that would be something like the FBI building or the CIA building, where it's very tightly restricted as to who can go in and who cannot go in. Your staff area, a non-public forum would also be something like a store, right? Because the store is not is not answerable to the First Amendment. It's not a government entity. It's a private commercial entity, and they can, anything from prevent guns to, prevent certain slogans. I mean, they have a lot more authority to be restrictive than a government entity does. So along with those three public forums, which kind of set your overall ability, say, okay, even though you have to respect and you have to foster and you have to encourage people's constitutional exercises and constitutional rights, you do have the ability to have some restrictions. The limits to that restriction for libraries, as far as being a limited public forum, the laws will say time, place, and manner, right? So the limitations pretty much have to be almost what you would think of as objective, right? So public libraries, what courts have said is that public libraries can create regulations and restrict access as long as those regulations are narrowly tailored and content neutral to achieve the specific objective of the regulation and support the operation that is the purpose of that entity. In other words, you can have rules and regulations that support the operation of the library, right? Support the ability to provide information. And as long as those rules and regulations are content neutral, which means they are not viewpoint based. So that means that the enforcement of those rules cannot be based on the content of the speech, right, of whoever is violating the rule or allegedly violating the rule. Or your rules can't say, for example, you have to be civil in the library when you talk to people, or you can't, you must be civil when talking to staff. Like, that would not be a policy that would be in keeping with this. You can't restrict speech. You can't restrict what people say. You can restrict their behavior as far as the ability to protect the ability of others to use the library and to protect library operations and to protect the ability of library staff to do their duty and to do their jobs, as well as to protect public safety and the integrity of the facility. So you have to, consider that when you're considering enforcement and when you're considering drafting your policies. So when we talk about enforcement and the authority of enforcement, it's important to note, and hopefully, this goes without saying, that safety is always more important than enforcement, right? And this kind of, there are incidents when you may think, okay, you know what? And the First Amendment auditors is a good example of this, where we have said, look, with First Amendment auditors, a lot of times it's better to just let them do their thing, right? And that is not always because of safety, but it's a risk-benefit calculation, right? So you say, what is the likely outcome of me enforcing this rule versus the likely outcome if I don't enforce it? What's the risk to me not enforcing it versus the risk to me enforcing it? And with First Amendment auditors, because of the conflict and because of the likely result, if you start to enforce or you interfere, most often it's not worth the effort, because they tend to just go away if you don't enforce, if you don't get involved. They tend to just kind of stop what they're doing and leave. Whereas if you get involved, they tend to create a ruckus, right? Which does not enhance anybody's safety, or really do anybody any good. But in those instances where you have to make your staff, or you have to make a decision on the fly as to whether or not, you're going to, enforce a rule with somebody who, may appear to be a threat to himself or others, obviously that's not necessarily going to be the time to say, excuse me, sir, maybe you need to stop what you're doing. That may be a time where you pick up the phone and you call law enforcement. So, again, one thing in the back of your mind is that safety is always more important than, actually enforcing the library's rule. However, that being said, it's important to also note that many times, when you are enforcing common rules, like when you're enforcing everyday rules, part of the reason you have those policies is to enhance the safety of your facility, to encourage the safety of staff and safety of patrons. So, this can be when I say safety is more important than enforcement, what I mean is in those kind of more extreme circumstances. I'm not talking about a situation where someone feels uncomfortable enforcing a rule that could have safety implications, like don't use the elevator because it needs to get fixed, or don't please don't climb on the chairs. Don't let your kids climb on the chairs because they may fall off and hurt themselves. Those are the kind of rules that you have to enforce, even though it's uncomfortable to enforce it, because that is, again, public safety. We're going to talk about later, there are some risks to you as a public entity if you don't enforce your policies. So again, there's a fine line. You have the authority to enforce your policies against the visitors that violate them. However, there are certain buts here. So you want to make sure that you and your staff understand the limits of enforcement, right? Because you do have the ability to enforce your policies, but when you're considering your enforcement procedures, you want to understand what the limits of your ability to enforce are. For example, laying your hands on anybody, right? That is a very, very kind of gray area. It's probably best for you not to put hands on anybody, right? And that includes children, unless they're in imminent danger. Libraries are not schools. So the ability of staff in a public library to regulate children in terms of, say, forcing them to give up their name, right? Or restraining them or keeping them in the library until their parents arrive, or keeping them until law enforcement arrives. As we can't lock a kid in a study room while we're waiting for police to arrive, right? We can't physically restrain people. So that's, you have to understand what are the limits of your enforcement. Where in a school setting, it's different. They may have certain abilities to do some physical restraint or some, ability to sequester a kid, whereas we don't, because we're not schools and we're not imbued with the same authority or responsibility as schools. Now, if you're a school public library, there are some differences there, and that's where you would then talk to your administration and get those lines straight as to the line between your school library duties and your public library duties. And that's something, school public libraries are kind of unique. And so that's something that you would want to make sure you understand, because there can be constitutional, civil ramifications if somebody should choose to sue. And if, God forbid, someone gets hurt in the process of attempting to restrain them or chasing after them, then the library could possibly also be liable for that. So you have to really be careful when you look at enforcement, right? What are the limits of your ability to actually enforce? Sometimes, if someone runs away, you may just have to let them go. You have your security camera footage. Hopefully you have your staff who may know these people from their interactions with them. And that would be evidence and information that you would have to provide to law enforcement should you choose to report the violation if it rises to the level of a crime, or if it's a more benign thing. Those are things you can use to enforce an internal, a library type penalty, as long as you follow your internal procedures as far as discipline and enforcement go. The three-step process. When I say enforcement, sometimes I'll be more clear, because enforcement could mean the actual, in the minute, hey, you're doing something wrong. And it could also mean, the further process of, say, punishment or ramification. You want to make sure that when you're looking at enforcement, you also have to consider, in addition to what your limits are legally, you also have to look at things like age appropriate enforcement. There can be culturally appropriate enforcement. There may be certain ways you would enforce. You may enforce a rule or give a reminder or a caution to a particular patron, depending on, you want to be culturally sensitive, right? So there could be certain methods you would use in one circumstance that might not work in another circumstance, depending on the cultural differences that you might run into. There are some cultures where, a man talking to a woman that they do not know or are not, affiliated with is problematic. So, there are certain nuances and culturally informed practices that are good to know, especially if you are in a community that has a high level of diversity. So again, part of this goes back to understanding what your demographics are of your community and how that's going to inform your enforcement of your rules. You want to make sure that you talk to your attorneys with these things, so that you have legal and DEI informed legal enforcement proceedings. Some other things to consider are that line where the library's ability to enforce its rules may step over the line with someone else's individual constitutional rights. And so again, these are things that you have to discuss with your attorney. What you want to do is make sure, I would recommend nowadays, okay, because this is on everybody's radar. And when you are dealing with a difficult situation and your instinct is, there has to be something I can do here. We should be able to prosecute this person, or there should be a law that prevents this person from doing this. One of the things to consider is, what are your rules in your library? What are your policies and what are your enforcement procedures? And how can you tighten those up so that you have the best policies possible to address the issues that are most concerning you right now? And you want to work with your attorney to make sure that you have those policies that are as legally compliant and as legally tight as you can make them. And then your enforcement procedures are also as legally compliant as you can possibly make them. And then the third component of that is training, right? So if you have staff who are going to be expected to enforce these policies, you know, if you're enforcing them, if you're a very small library and you have only yourself and one other person and you're enforcing it, well, in some ways that can be a little bit easier, because if you create the policy, you understand what the purpose of the policy is, what the impetus of the policy was, why did you create this policy, what is the policy intended to do, what are the limits of this policy. You have a better sense of that if you created the policy. But if you're creating policies for other people to enforce, it's vitally important that those other people are trained to understand, why is this policy there? What is the intent of this policy? What did you mean for this policy to do? Under what circumstances does this policy get enforced? And how does this policy get enforced? What does violation of this policy look like? Right? Because if all of those aren't made clear and you're sitting at a service desk and you're expected to address these violations or to warn patrons that they're close to violating these policies, but you don't know what violation looks like, you can be in real danger of, you know, falling prey to your own biases, or having, you know, a staff that's implementing these policies incorrectly, which could put the library in a space of liability. And that is something that you don't need on top of all these other things that are happening in libraries, right? Because none of us want trouble, right? None of us are asking for trouble. But if you don't do this in a thoughtful, careful, legal way, not only will you have trouble when you try to enforce it, because you'll have, you know, the usual trouble, people push back, people don't like to be told they're doing something wrong. But then on top of that, if you're doing that in an incorrect manner, now that person may have cause to come back and sue you, or they may have, you know, cause to, you know, spoil your reputation online, affect the ability to get a millage, create bigger problems for you. So, you know, at the, you know, at the very least, to give you a hard, you know, to kind of, you know, stress out your staff and give them a hard time when they see them in other circumstances. So it's, you know, again, I cannot stress enough that it is very important that your policies are well drafted, and that your enforcement procedures, because all of us have been talking about policies, right? And a lot of libraries already work very hard on their policies, and they work very hard with their lawyers. But the enforcement component of it is something that I think a lot of libraries do not, or have not in the past, put as much thought into, because it's one of those things that all of us, right? It's you know, we go up, we tell someone you're doing something wrong, right? And it's not until something worse happens that we really think about, well, gosh, what can I do and what can't I do? And these are the things that you want to be informed of ahead of time nowadays, before you have someone screaming at you across the circ desk that you're a pedophile, or before you have someone that comes and knocks a display of books over, or before you have somebody who, you know, returns a book with a shotgun hole in it, which is, you know, what has been happening in some other states, you know, so that you can put the appropriate mechanisms in place to deter this and to address it if it should occur. And then it's successful, right? Because if you enforce incorrectly, well, now, you know, your ultimate enforcement is likely to not be successful. And then it can also damage your ability to enforce other things, because you lose some credibility. So let's talk about the types of violations, right? As we get a little bit more into some of the nitty-gritty legal stuff here. the types of violations that we're talking about are things like damages to your facility or materials, right? Vandalism. Vandalism would be intentional destruction. So whether that intentional destruction is a symbol or a word or a phrase written on a wall, or whether it's defacing a book return, whether it's defacing books, like I said, the shotgun hole in the books, whether it's someone ripping pages out of a book, whether it could even possibly be someone moving books around, right? So somebody making it so other people can't find books could also be kind of a subset of this. So vandalism is by definition intentional. Okay, so in order to have be accused, not be accused, in order to be convicted of vandalism, it's an intentional thing. So you're intending to cause damage to something. Then you have things like accidental damage, and this would be more like somebody spills a Coke on a computer, or somebody accidentally pees on a chair, right? They didn't do it on purpose, but they did it, so that's accidental. It can still be, you can still enforce against it, right? There could still possibly be a penalty, even though it was accidental, because it was still done. But obviously the enforcement for accidental versus intentional versus a vandalism, or I'm sorry, not the enforcement, the penalties may be different, but the enforcement would likely have to be the same, because sometimes you don't know, is something definitely accidental, is something definitely intentional. The difference in terms of whether or not you get law enforcement involved could be dependent on whether this is, again, a spray painting on the outside of a building, or serious high cost damage versus minor small damage. Theft, so people stealing books that they don't like, or people, other types of theft, computers, other types of library materials. Obviously, there is a statute in Michigan that specifically, addresses the theft of library materials, and it's under larceny in the criminal code, and that makes it a misdemeanor to steal library materials. Now, this is kind of a useful statute because it's something that, again, as you're dealing with some of these, book banning techniques where they'll come in and they'll check out the book and they'll never return it. One of the things you could add to your notices, that when you are, putting out a overdue notice, and you're putting out your third overdue notice that somebody's not returning the material, and I would think you could even put this in the first overdue notice in your standard language at the end of your, letter or whatever, you could say, the Michigan statute, and you could, we can put the statute in there, makes it a misdemeanor to steal library materials. Not returning your library books when you're supposed to could be considered theft of the library material. So, as an extra, sometimes, someone who is checking out that library book and not returning it because they don't want that book on the shelf may not realize that they're committing a crime. And if you put that language in your overdue notices, or in your notices to them that, hey, we've noticed you have this book out for, since last September, if you put that language in there and you cite the statute, there's not a whole lot they could come back with, because it's absolutely true, right? And if they don't come back with it, then you could talk to your lawyer, talk to the prosecutor. It is possible you could charge, you could submit that and have them accused of theft, or have them charges brought against them for theft. Now, again, as we're going to talk in a minute, there's a cost benefit analysis to that. But just putting the note in the letter, just telling people that what they're doing is a criminal offense, can get their attention. And if you have the odd person who just thinks that this is a way to beat the system and to get these books out of the library, might be a way to, to deter that. We have injury to people. So you have intentional injury. So this would be things like assault and battery. So assault, you hear those terms around a lot, I'm sure. So assault is different than battery, right? Assault is an attempt to cause physical injury. So an assault would be if I raise my hand to you, if I threaten you with physical damage, or if I, have an item in my hand, a baseball bat or whatever, and I'm waving it around and I'm threatening to hit you. So that an attempt to cause physical injury is assault, right? You don't actually have to be injured in order for it to be assault, right? Battery is the actual infliction, right? So if I punch you, that's battery. If I hit you with something, that's battery. Even if it's, there's degrees, right? So if I throw a book at you, right, and it misses you, it could be, it's assault. But if I throw a book at you and it hits you, even if it's just a little flimsy paperback kid's book, it's still battery. So, if you have, again, and these are all things to talk to your attorney about, but in the course of, talking about issues that your library may be going through and talking about incidents that, especially reoccurring incidents, if you have, people causing a ruckus and you have somebody, who's making some kind of threat or overtures, it's handy to remember, this difference and what is assault and what is battery. Again, you also have accidental injury, right? So if someone accidentally hurts someone else, spills something hot on them by mistake, maybe, we've all been in situations, especially with kids, where, you're doing something and all of a sudden there's a little body in front of you and you trip over them and they fall down. Something like that where someone gets injured, that's an accidental injury. So that wouldn't be a crime unless there's some kind of significant negligence involved, right? So the library has has not been very good about its upkeep, and it has a stair or maybe it has a floor that has tiles missing or something like that. And that same scenario occurs where someone trips over a kid and the kid falls and smacks his head on the corner of the empty tile and is bleeding. So the fact that the library did not maintain its floor and it's a public hazard, that could add a level of liability and negligence to the library that may have not been there if the library had been maintaining its floor. This is the same thing, incidentally, with the library and employees, right? So if you have an employee who injures themselves, if the injury is caused or compounded by a situation that the library should have had under control, so it's a situation where, again, maybe it's a public safety situation, again, was not maintaining the floor properly, was not, had a leak in the bathroom that it knew about and did not stay on top of it, so the floor was wet and slippery. Those kinds of things could create another level of liability for the library. And then, of course, now, we also have emotional issues, which, you have someone coming in the library and screaming at you. Now, this has a lot of layers, right? This gets a little bit sticky when it comes to emotional issues. There's been a lot of discussion about like defamation and to what extent can libraries and other public facing people protect themselves from members of the public that come in and verbally attack them, whether that's in a public meeting or whether that's in the library, or even whether that's out in public and you're at the grocery store. There's lots of levels and layers to this kind of litigation. Right now, in a lot of states, there have not really been cases where people have really, where librarians have really won this kind of, including here in Michigan, where someone has won a libel or a defamation suit against a member of the public. because in Michigan, there is, when you're talking about defamation, if you're a public figure, you have to prove what is called actual malice. And that means that you have to prove that the person who is yelling at you intends to cause you great harm. Like there's a definite intent to cause you great harm. They're not just blowing off steam. They're not just getting rid of their political baggage. They walked into that library with the intent to cause you emotional harm. And that's a very high bar. That's a hard thing to prove. So that's one of the big reasons why a lot of these defamation cases have not been going through. Now, there's discussion back and forth about, why isn't there legislation that says, you can't verbally abuse members of the public or members, public officers. Now, there are laws in Michigan that, especially if they're in the school code, that say you cannot verbally harass school personnel. Now, what's important to note about that is that when that law was passed, and it's fairly recent, there were a couple schools that implemented that and came up with policies. The law says you have to have a policy. The problem was the very first time those were tested, the people who were where it was enforced against sued, and the courts struck down those policies as unconstitutional against the First Amendment. So it would seem right now that law in Michigan is pretty much not enforceable because of these cases that came through and called them unconstitutional. So it's very difficult to have legislation that limits your ability to speak, that limits speech. It's a very sticky, difficult thing to do. And part of that is because it's very subjective. So when you talk about verbal harassment, what is verbal harassment? To one person, verbal harassment could be someone coming up and yelling at them and cursing them. Another person, verbal harassment could just be if you're raising your voice. So we all have different levels of what we can handle and different levels of what we think is appropriate. And so because of that, it makes it very difficult to legislate any kind of behavior that involves speech. And our Constitution makes it doubly difficult to do that. So that's some of the reasons why it's going to be very difficult to have some kind of ban or restriction on the ability of people to walk in the library and yell at you or say inappropriate things to you. Again, you can always enforce behavior. So that would be things like yelling would be a behavior, not what they're saying, but the decibel at which they're saying it to you, right? If they are taking a step towards you, or they're wagging your finger in their face, or all of those things can be dealt with. All of those can be enforced, right? You can say, you can enforce that as bad behavior, right? Interfering with a member of the staff in the course of their duties, threatening a member of the staff, like all of those things are easier to lay out as in order to show a definite violation of the rule, as opposed to something that is subjective. You never want to have a policy that says something like inappropriate. You cannot treat the staff inappropriately, because appropriate is very subjective. Right? So you have to make sure, again, that your policies are written in a way that it's very, very clear as to what constitutes a violation. So you could say, you cannot raise your voice to staff, but you can't say, you can't, insult staff, or you can't use profanity. So again, you can enforce behavior, but you can't enforce speech. And that's unfortunate that people are being so nasty. But unfortunately, right now, that's pretty much the state of the law. And again, I would encourage you to talk to your attorney. There are shades of this now. So if you look at certain types of if someone comes in and calls you the B word, okay, just for as opposed to certain other racially motivated slurs that, okay, that would turn into something else, right? So you could have someone yelling at you, but if they start delving into, certain insults that could be looked at as discrimination, possibly, then there may be a different outcome. But the problem is that this is very, very gray. Again, speech is very heavily protected. And even when you talk about hate speech, right? Unless you have a very clear law in the state, that documents here's, under certain circumstances, you can't, it would be very difficult to even enforce like behavior policy against someone that comes in and even uses a racial slur, unless that racial slur is combined with some kind of behavior that, is threatening. Then it's quite possible that it would be successful to enforce against that. And again, when I say successful, I mean not that, it means whether or not the person can come back and sue you, right? So does it mean that you absolutely can't throw somebody out? Well, it means that if you throw somebody out for the wrong reason, you could get sued. And that's, whether or not someone sues you is a crapshoot. So, and that's unfortunate that things like hate speech is technically legal, but right now that's the case. One area that is something to discuss with your attorney, in part because it's so new, is that, we do have the amendments to the Elliott Larson Civil Rights Act right now, which, have added LGBTQ plus and gender identity to the protected classes in the Elliott Larson Civil Rights Act. So, when you're talking about discrimination, if you have a patron who comes in every day and goes after one particular staff member who is a member of the LGBTQ community, or for that matter, is a member of another protected class, and the behavior rises to the level of intimidation or harassment or threat, all of which are illegal. Those three things. So it's not what they say. Again, it could be behavior. There may, you may have a situation in there. There may be a couple different situations. There's a situation where, the library needs to figure out how to address and enforce a behavior policy against this patron, but they also have to look at the employment environment for this particular employee, and is this creating a problematic employment environment for this employee who's being regularly attacked. And so, those are some other things you have to look at. So again, it's kind of, there are very many shades of gray. You can't have rules that say you can't say XYZ, but at the same time, depending on certain scenarios, right? When you're dealing with discrimination and when you're dealing with constitutional issues, it's all about the facts. It's all about the specific scenarios, which is partly what makes this so hard. Depending on the scenario, there may be a way to snag and to enforce against that particular patron, but it all depends on the individual scenarios. Just going after a patron because they come in and tell you you're a pedophile or tell you that you're a groomer is not going to fly if that person is not also engaging in behavior that enables you to address that behavior and not the speech. And that stinks, but that's the way it is right now. And again, if you are faced with that, I would definitely talk to your attorney. And in fact, I would encourage libraries to talk to their attorneys now. If you have not been facing that, talk to your attorneys before you face it, so you know how to reply and how to address that kind of action should it occur. And I think that would make everybody feel better. Part of the damage of these attacks is the suddenness of them and the unexpectedness. When you have a member of your community that comes in all of a sudden and starts telling you the most horrible things. You feel like a deer in headlights. It's horrible. So, you know, having some kind of preparation and understanding possibly how to address that when it happens can help your staff and you have a certain amount of security and protection that can, you know, can help, even though there isn't a huge amount of, you know, maybe enforcement that you can do against these kinds of things. Okay, now we have threats like bombs and shooters. This is also becoming a thing coming up in the libraries where people are calling in bomb threats, people are calling in, or people are threatening, you know, to come. I hope nobody comes in and shoots you up. Or in Michigan, it's definitely illegal to either call in bomb threats or threats of active shooters. It's also illegal to make those kinds of threats. So again, this would be something to address in a policy, so that should this occur and you have a staff member at your CERC or reference desk and they receive a call, they know exactly what to do to implement everything from calling law enforcement to possibly identifying the call. You know, if there's caller ID, you have a big patron database of phone numbers, right? Or possibly, and also knowing what to do with the building. Do you clear the building? So these are the kinds of things that, you know, you would talk to in the process of policy making, talk to your attorney and possibly talk to your municipality and talk to your law enforcement to figure out, okay, what is the best way to handle this? And here's our step-by-step guide. Should this occur, these are the things we're going to look at in the call. This is what we're going to do as part of public safety to make sure that, you know, in an abundance of caution, to make sure that, you know, everybody remains safe. And then this is what we're going to do to figure out, you know, what kind of information can we assist with the police in order to find this person. So in Michigan, when you're looking at, you know, laws and you're looking at solutions, there are two sides, so to speak. You have a civil laws and you have criminal laws. So criminal laws by definition are violation of the Michigan Criminal Code. So the penal code, the same people that bring you penal fines. That's also the code that protects or lays out the various laws that prevent crimes and define crime, like the assault and battery we were just talking about a little bit. Generally, when you talk, criminal is generally intentional injury or intentional threat, although it doesn't have to be. There are some accidental things that could be crime. So intentional injury against persons or property. And intentional threat would be things like, again, personal injury or facility damage. So again, your threats against people, threats against the building. And this can be either called in or in person. So if you have somebody who stands, you know, a patron who is angry, who stands in front of you and threatens staff with physical harm, you know, that's also a crime, right? That is not okay to do. And then of course theft, which we've discussed. And then we have the civil side. Now, the difference between criminal and civil, okay, to give you a little bit of a background, is criminal laws are things that are enforced by law enforcement, right? Those are things that are largely handled by the police. So, you know, especially when you're talking about states, so it could be municipal. There's the criminal code in Michigan, you know, the Michigan statutes. There's also maybe some municipal ordinances and municipal crimes, but those are all enforced by the police, right? So if you suspect a crime has been committed, you generally call law enforcement, and then law enforcement comes and they deal with the situation, and then it goes to the prosecutor, and the prosecutors decide, you know, how and if to you know, prosecute it and send it to a court. When you're talking about civil, okay, civil is totally driven by the parties involved, right? So when you have civil violations, you don't have like a police force you call, right? So when you have constitutional violations, like, you know, we talk about, violations of First Amendment, and you can't legislate speech, and those are all civil. So the risk of civil is someone suing you, okay? And yeah, there's this risk benefit, right? So you impose a policy that might not meet constitutional muster, but you think, what's the likelihood that someone's going to sue me, right? This is something, again, to discuss with your attorney, because they can be, for your particular situation, the best judge of how far you skirt that line. Because if you get caught and someone does sue you, because you're a government entity, there are some very, very big lawsuits that could ensue. And we're going to talk about that in a minute. So things like we talked about: defamation, First Amendment issues, even Second Amendment issues, right? So right now, people can bring guns into Michigan libraries. If you attempt to enforce a no weapons policy, this also could be something that someone could come back and sue you for. Civil rights violations. Okay, so if there is a situation where either there is a perception or an actuality that certain persons in your library is enforcing policies against one protected class over other people, then there could be a discrimination issue, right? As we talked about with the Elliott Larson, some of this, there's been discussions of, well, if we get rid of LGBTQ books, or we decide we're not going to we're not going to purchase LGBTQ materials because we're concerned about this situation, could that be considered discrimination? And to be honest, I've actually been doing research to figure out whether or not to see if there's case law and legal authority on, is the failure of a library to represent a particular group considered discrimination? And I have not found very much yet. I have found cases in the past where the Black community was not represented in libraries, but a lot of those cases have more to do with the prevention of members of the Black community from using libraries, so segregation, more than the inclusion of Black materials in the library. So I'm doing research on that. I think that's actually a very interesting angle. But yet I have not yet found anything that says that it would be discrimination, but you know what? I can't say it isn't either. And then there's also equal protection. So what's the difference between discrimination and equal protection? Well, discrimination is where you treat people differently because of their race or religion, or their protected class, or their some characteristic. Equal protection is when you fail to act on behalf of somebody. So equal protection a lot of times deals with things like, is law enforcement adequately representing certain citizens as well as they are other citizens? Like, are they protecting them as equally as they are others? So equal protection and discrimination are very closely related, but they are a little bit different. So what's important to understand about the legal categories is so within standing from behind the desk in the library, neither one of these is really under any of our control, right? So if you have someone committing a crime in the library, you call law enforcement, and then law enforcement comes, and it's up to law enforcement whether they take it further. And then if they take it further, then it's up to the prosecutor whether or not it goes even further than that. With civil violations, it's up to the person that is harmed, whether or not, or allegedly harmed, whether or not they come back and sue. So whether that person who is harmed is the library itself can decide to sue, or whether it's somebody, a patron or someone else. So, you know, when there's talk about, well, there has to be a way for the law to deal with this, the unfortunate thing is that in a lot of instances, whether or not the law works is out of our hands as the library. All we can do is call. So that means what we have available to us that is the most important thing is our policies and our enforcement procedures. And that's why those are so, so important. So what are your options? Well, your legal options are, first, foster and maintain relationships as much as you can with your local law enforcement, right? Find out what are the expectations the library can have of service and assistance when it comes to some of these issues with law enforcement, right? Find out you may do this through your attorney, or you can contact your local law enforcement directly. You know, talk to your law enforcement, say, hey, if someone comes into the library and is doing X, you know, and we call you, what do you think? What would be the likelihood? What can we expect? And again, a lot of this can be situational, but just like all of us, the police also have certain procedures and processes they have to follow. Talk to your attorney about the process and about the prosecution process, right? So if you want to know more about this, okay, we call the police, they come, they talk to the people involved, they talk to the staff, and then they may arrest and take this person away. Well, what happens next? What can we expect? Are we going to have to testify? Is the library going to have to testify? Do we have to provide documentation? What about the Library Privacy Act? What is going to happen? It can be helpful for you just to understand the background here. You know, what in general is the process that's going to happen? Have a policy and procedure for your enforcement, for law enforcement. When do you involve law enforcement, right? Do you involve law enforcement? You know, what are the rules? I've worked in libraries where the rule was anytime a staff member felt unsafe, or anytime a staff member felt, like there was a situation that could get out of control, call the police, right? Default to calling the police. I've been in libraries where the rule was you do not call police until you go through someone higher than you who tells you whether you can call police. You know, that one I'm not necessarily sure about. I think that one's a little iffy, but, you know, talk to your attorney, talk to law enforcement and find out. Because there is something to say that if you're a library that cries wolf too many times and keeps calling law enforcement, is there going to be a time when law enforcement might not come because they have, too many other things going on, or they have, competing calls, and they say, you know what, the library calls all the time, and it's always not really anything. Is there a way that you can make the library inviting to law enforcement? You know how you have like at Walmart or Target, certain areas you see they have special parking places for public safety people, or they have a special, little office or desk set aside for law enforcement to come and be there and visit and have a place to sit. Talk to law enforcement, talk to your attorney. Maybe if you are a library that's experiencing a high incidence of problems, or you are brewing a big controversy, maybe that's something to consider. Talk to your attorney, talk to law enforcement about maybe having an officer who comes around frequently and just sits in the library, walks around the library. Depending on where you are, it may be possible, it may not be possible, but it's definitely something to inquire about. There could be some other issues there regarding the library's, duties towards the First Amendment, but these are things that you would talk with the law enforcement about and talk with your attorney about to communicate with law enforcement. What kind of documentation are you going to need if you involve law enforcement? Do you have incident reports? Do you know what I mean when I say incident reports? Every library should have a system where there is documentation on things that occur in the library, particularly if you're calling law enforcement. Hopefully you have documentation for whenever anything happens where a member of the staff has to enforce a particular policy, and you can lay out, at what level, is it serious enough that you have to do a incident report. You don't necessarily have to do an incident report every time you're telling someone to be quiet. But you should have a policy that says this is when you need an incident report. The incident report is typically a form. It could be an electronic form. It could be a paper form that says, here's what happened. Here's the name of the staff member on duty. Here's the day and time it occurred. Here's the name of this of the if you know it. Here's the name of the patron that was involved, and here's what happened. And the person just writes out their side of the story. That way, if something happens, on January 5th, and then all of a sudden in May, it comes back to bite you because someone files suit, you have the documentation that was written at the time it happened, which from like an evidentiary standpoint is more valuable than having, a staff member sit down and go, well, this is what I think happened. So it can be very valuable from an evidentiary standpoint and from just a way to know exactly what happened at the time it happened. It can also help because you have staff members that are sitting at desks when sometimes at times there are no management around. So if they have incident reports, that protects the staff member, and it also can protect the library. Do you have security footage? Again, that security footage would be used in concert with the Library Privacy Act, which says Library Privacy Act says security footage is not considered a library record and is not protected by Library Privacy Act unless it contains images that attach an identifiable person to services or materials in the library. So that means that if you have footage of someone doing something, let's say yelling at a library staff member, but in the background, you have pictures of patrons reading books, and you can see the title of the book and you can see the patron's face, or people working at computers and you can see their face and what they're looking at, that footage has to be cropped out or redacted from the footage of the person perpetrating the alleged crime. If, witness statements, right? The Library Privacy Act says that one of the exemptions, the Library Privacy Act, is personal testimony. So again, something happens in the library, the police come and they say to the staff member, what happened? The staff member can tell them everything that happened, including the name and the location of the patron. If they know it, as part of their memory, they can't go look it up in the computer, but if they know it, they can relate all of that to the police officer, and it is not a violation of the Library Privacy Act. Train your staff, right? So you want to make sure your staff is really well trained for their sake and for the library's sake. Your expectations of enforcement, your expectations of exactly what are enforcement procedures, right? How do you address patrons who are allegedly violating a policy? How do you deal with a matter where one patron comes and tells you that another patron is doing something? How do you investigate to see if that's really true? How do you take information? How do you ask questions? How do you talk to staff, or how do you talk to patrons who are very upset, right? All of these kinds of things as part of that training, right? The training on niche and web junction, on de-escalation and dealing with problematic staff are all things that should be part of this training of staff. How to document, how should incident reports be filled out, right? What is the correct way to fill it out? If you have hired security, what is your expectations of hired security, right? Know the terms of the contract with the company. If you hire a company, or your municipality hires a company to patrol the library or to service security in the library, what does that contract say with limits to what is the security officer permitted to do? What is the company's expectation? Does the security person carry a weapon? Under what circumstances are they allowed to use it? what kinds of limitations or what expectations does the security company have with regards to physical restraint? So these are all things that, when you're dealing with a security company, things are different than if you have library staff doing the security. So these are things that you're going to want to understand so that the library staff knows what to expect when a situation comes up and the security people step in. What are the security people allowed to do? So that if a library staff member goes to a security man or a security person and says, hey, can you take care of this? And the security person says, no, that's not within the scope of what I can do. That can be really frustrating if the staff member doesn't understand beforehand what is the scope of the security contract and the scope of what the security personnel can and cannot do. What is the ability of the security person to be involved in a legal proceeding if it comes to that? And now we talk about risks to the library. So as I said before, you have your enforcement scheme, you have an idea of, the crime that was allegedly committed, and you're deciding, okay, what are the risks? If we're going to have this enforcement scheme, what are the kind of risks that we run? Well, the biggest risk is liability, right? And there's a couple different areas of liability. So under federal law, there are two statutes that govern government entities interacting with the public, right? One of them is 42 USC 1981, and one of them is 42 USCA 1983. 1981 deals specifically with equal protection, and 1983 deals with constitutional rights and more like discrimination. So 1981 would be if, and this very often these are enforced against the police, but they can be enforced against any government entity. So essentially, if a government entity is violating a person's constitutional rights, it would be a 1983 violation. But if they're violating their equal protection, which means they are failing to, do their duty or protect or give that member of the public the same service and the same protection as anyone else, then that would be a 1981. So both of these have slightly different penalties, but both of these are civil actions, which means that someone sues. And because it's a federal suit, this gets very expensive very fast. If you lose, it can be a whole lot of money. So, a 1981 and 1983 suit are the common ones that get filed against government entities on behalf of individuals that have been had rules enforced against them. Then you also have regular liability, and the Governmental Liability for Negligent Act is a Michigan act that says, you might hear a lot about sovereign immunity, right? Which, is the theory that government entities can't be sued for something that they do. And this is true and not true. So Michigan does have governmental immunity. However, governmental immunity can be kind of punctured by if there is gross negligence on behalf of the government entity, particularly where it comes into play with public safety. So again, you think of the facility not being properly maintained. There could also be an issue if staff are not properly trained, or if staff, you have a staff member that is doing things improperly and is maybe acting in a discriminatory way or violating constitutional rights, like enforcing rules against speech, then it could be that the governmental entity would be liable because, again, you have some gross negligence there where you have an entity that knew it had an employee that was behaving incorrectly and violating people's rights, but didn't do anything about it. And then you always have employment liability as an employer. Again, if you have either staff that are not behaving properly and you know it, or you have staff members that are being harmed because of a workplace hazard or because of workplace negligence, you could also have issues there. Cost is a huge risk, right? Legal representation, especially good legal representation, is not cheap. It is worth every penny, but it is not cheap. The more legal actions you undergo, the more that cost is going to rise. If someone sues you, you are going to end up having to defend yourself, which is going to cost money. If you lose, you're probably going to have to pay court costs, and you may have to pay attorney's fees for the other side, which again, in and of itself can be hugely expensive. If you're sued and the other side wins, you can have a judgment levied against you, which again could, on top of court costs and fees, could be another huge amount of money. So, even though you may say, well, the idea that someone's really going to sue us and win is probably limited, you also have to consider that, yeah, but what if? What if, and then what if they win? So these are things that in conjunction with your attorney, you would want to look at carefully when you're weighing the kind of action that you're going to take. And then lastly, you have your reputation and community relations. Remember going back to the beginning where we talked about, community history and reputation. Library still has to be funded, right? The fact is, whatever happens, you're still a community-based entity, right? You're still, there every day talking to members of your community. So if something happens and you end up on the wrong end of something, or you end up in a situation that your community is upset about, well, that could affect your funding. It could affect the ability for you to recruit board members, or recruit, the kind of board members that you want to work well with. It could also affect your ability to recruit good employees and retain employees, right? And that works both ways. If you're an entity that doesn't ever enforce your policies, and so your library is kind of a ball of chaos, then your employees are not going to feel safe, and they're not going to feel comfortable, and they're going to want to leave. On the other hand, if you're an entity that is constantly enforcing, and you're enforcing inappropriately, or you're enforcing without really thoughtlessly, then you're going to have an environment that's too restrictive, an environment that your employees are going to feel uncomfortable with in that as well. So again, it's a balance. And I know I keep saying it, but it's a balance that working with your attorney is the best way to manage, to get those policies and to really understand your options with regard to enforcement. And because it's not easy, there's not easy answers. But if you understand what are the risks for different types of enforcement, then your library can make a good decision on what is right for your library and what is right in particular situations, and what kind of risks you are willing to take on, and you are willing to well train your employees to take on. So what do? Well, get a plan. Get a plan now before you have issues. Look at your enforcement. Look at your policies. And I know we say this over and over again, but it is really important. Please, please, please hire and work with an attorney. I know it can be expensive, but it's worth it. Even if you just have an attorney that you can just call once in a while when you need it, right? Just have an attorney to work with you initially on policies and enforcement procedures. And then you don't have to retain an attorney and pay them like monthly. Just retain one for projects if that's what you can do. And then if you have a situation where someone sues you, or where you have a question, have someone you can just call on an as needed basis. Because there's really, especially nowadays, there's just no ways around it. The issues we're dealing with are too legally complex and have too large a ramification for the library to just kind of wing it. So I strongly suggest that you do get some kind of legal representation. If you don't have a lawyer and you would like some names, I have a sheet that I keep updated. Also, if you are a municipal library, like a PA 164 library, and you're only using your municipal attorney, you want to get a library attorney, at least a name, a phone number you can call when you need it. Because if push comes to shove, your municipal attorney represents your municipality, does not represent the library. Foster relationships with law enforcement and your municipality, okay? Especially your law enforcement. Just get to know them and get an idea of you know, what their policies are and how they do things and what they recommend for enforcement. Policies we talked about. Make sure when you have your policies and enforcement procedures, you post them so members of the public understand here is what you can and cannot do, and here are the ramifications if you violate this. Here is what will happen. Make that very clear, because people, you know, you can't fairly enforce something against somebody who doesn't know they were doing it wrong. I mean, you can enforce it, but you can't punish them, right? So make sure people know. Don't let that be an excuse people can use to behave badly. Make sure they understand this is exactly what you can and cannot do in the library. And this is exactly what the library is here for. And this is what the library is not here for. Okay, the library is not here for childcare. The library is, you know, not here to be your own personal, you know, repository of things only you like. You know, have your issue statement, have your vision statement, your strategic plan available to the public, and have your policies and procedures very clearly posted so that people can get to them easily. Keep your board informed and trained. Right? I know that library directors do the Herculean amount of work in a library, but the fact is, in Michigan libraries, the board is the boss, and no amount of thinking on a library director's part and no amount of you know, a strong library director is going to negate the fact that legally it's the board that's in charge. And so it's very important to keep your board informed and trained, that they know what their responsibilities are. And if there is a lawsuit, it's going to be against the board. It's going to involve the board. So it's very important that things like, you know, incident reports, especially, you know, big incidents, that the board is notified when things happen. When things happen that could rise to the level of needing law enforcement or could rise to the level of creating a community controversy or rise to the level of someone could sue, make sure your board knows. Hiding information from them is not going to be good for you, and it's not going to be good for the library. Okay, because in Michigan, again, the fact is that the board is the legally responsible party, and just deciding that they're not isn't going to make that so. Make sure your staff is trained and keep training, right? Ensure that the staff understands here's what we expect of you and here's what we don't expect of you. Right? We don't expect you to be a hero. We don't expect you, you know, just because you tell someone not to do something doesn't necessarily mean they're going to stop. Here are the limits of what we know you can do and what we know you can't do. Right? And anything beyond that, here is what you need to communicate to us or to anyone else. And also, if you go beyond that, here is what could happen. Right? So ramifications to staff as well. Okay, that brings us to the end. Here again is my contact information. I am not sure what time it is. It's 12:25. So it looks like we have just a couple minutes for questions. So let's see what we have. So we have a group middle school student that enter the library, shout racist slogans, and then run out. Is that protected speech? Yes, the fact that they say what they say is protected, but the fact that they run in, shout, and run out is not. It's the shouting here that is the problem. So I would say that if you know who these students are, I think that it would be legitimate to you know, treat this, that this is a in accordance with your enforcement policy. If you don't know who they are, and you have security footage, I think that that is reasonable to take a look at and talk to your attorney about how far you can go to identify them, whether or not you can take that to the school. Again, because this is an issue of them, it's the shouting, not what they say. So again, it's not the content of the speech here, but obviously if they're running in and shouting, they are disturbing the ability of everybody in that building to use the library. They're creating kind of a situation that is uncomfortable. And again, so that's behavior as opposed to speech. Would you have to add that language to all notices, or could you add letter you suspect are content motivate? I would add it to all of them, because then it makes it, again, you want to be careful about enforcing things only against viewpoint on viewpoint. So if you're adding that notice only to overdues that you suspect are because it's LGBTQ content or something, then you're really enforcing kind of based on viewpoint, and that would be a problem. So anytime you have a policy, you want to use it unilaterally across the board. So if you're going to add that language, you want to add that language on every overdue note that goes out. And you can phrase it, or you can even say, okay, we're only going to put it on the second notice and further. We're not going to put it on the first notice that goes out, that you're overdue by a week or two. But, when it gets to the point where this is the third notice going out telling you that your books are not back, then I would put it on there. There is kind of a balance that you could do so you don't freak people out. But that's a decision for you and your attorney to make. We have a litigious attorney who isn't returning materials. Does walking in with an item to bully other youth come under that? Oh, okay, there's two different things here. I think that I wouldn't worry about if they're litigious, because what you're saying is true. So I would say, again, if they're not returning things after, months, if this is like the third or, fourth, again, I would say the first time you send it out, you don't have to put it on there if you're not comfortable with that, but I certainly would put it on there. And there's ways to phrase it. I mean, you don't have to start the letter off with, this is theft, but at the very bottom, just in a matter of fact way, you could say, incorporate in the language with, and by the way, not returning library material can be considered a violation of, and put the statutory number in there. And the attorney would appreciate, they'll understand the statutory number. And when they read the statute, they will see very clearly that that's exactly what the statute says, that failure to return library materials and, stealing library materials is a crime. So, if, again, it's a matter of you're not saying anything that's not true, so they really don't have any reason to litigate. And as long as you're sending that message to everybody who has an overdue material, then there's really, like I said, they sue you? People can sue people for anything, and they do over the stupidest stuff, but, it doesn't mean it will go anywhere. And it's probably unlikely that they would sue you, because especially an attorney suing for something like that would be like a frivolous suit, and that could get them in trouble with the bar. So, does walking in with an intent to bully other youth come under that? That's hard, because you're talking about intent. And can you prove the intent? Can you prove that they're coming in with an intent to bully? Now, when they bully, so if they create an incident, somebody walks up to another kid and punches them, or walks up to another kid and takes their backpack, or walks up to another kid and, says things to them, or, harasses them, then again, it's the behavior. At the time that behavior starts is that's where the library now has a vested interest, because the library policies, that you can't do anything that is affecting the ability of other people to use the library. That's affected at that point where they're harassing that kid, because not only does it affect the kid, it affects people around them who are witnessing this harassment. So, that's at what point that the library would get involved. You have to be very careful about, incidents where, especially, where library staff know people and where they know, oh, this person's coming in to do this. Well, you can't really do anything until they do it, right? You can't, enforce a rule against someone before they've actually broken the rule, even if in your mind they're going to break the rule, or that they intend to break the rule, or they're just not a very good person. You have to wait until they actually do something. In terms of defamation, right now there's really nothing as far as defamation goes that you can do as a public officer, and your board members are definitely public officers, unless, again, if you can prove actual malice. And so right now, if you can prove that these people came in with an intent to harm these people, and and when right now this issue is so much in the public eye that it's hard to tell right now, to be totally honest, whether any of this discussion, when someone calls so and so a groomer or a pedophile, if that's really going to cause any damage to somebody. I can understand that if you're in a really small town, but right now this issue is in such the public eye right now that, if as a board member, a member of the public comes and calls you a groomer, but many, your friends, your family, your coworkers all know that that's not the case, it's hard to gauge whether that's going to cause long-term damage or not. But right now, there's really just not a lot you can do right now, other than, make sure that the public meeting rules for board members are, for public speaking are held to, limit the amount of time someone can speak. Don't speak back to them, all of those kind of rules. If someone starts yelling, that's a behavioral thing. And again, make sure that your public speaking rules address behavior. You can't enforce content, but if someone starts yelling at the board and starts stamping their feet and wagging their fingers, then that could be considered a public disturbance. So again, talk to law enforcement about being at some of those contentious meetings, and talk to law enforcement about what is their perception of public disturbance, and get on the same page as that, because if someone is creating a public disturbance, law enforcement can kick them out of the meeting. And so that could be an option. And then if they're yelling and stuff, then they can be kicked out of the meeting, and they're not being kicked out for their viewpoint. They're being kicked out because they're creating a ruckus. Unfortunately, other than that, right now in the law, there's not a whole lot. There is, I suspect that this topic will at some point go up to the Supreme Court, and we'll see what the ability is. I know that there's been a lot of discussions about this, and about, that idea of a public official, which every state does not have that. In Michigan, that is the current law. Now, there could be another case that comes up in Michigan that strikes that down, but right now that is the current law. And unfortunately, library directors and library boards are considered public officials for that. And that's the bar that can make this so difficult, is that actual malice limit. And that's one of the things that makes the defamation part so difficult. The other part is, even if we didn't have that, you have to prove harm and damage, which is not necessarily impossible, but the actual malice part is really the very, very high bar. Yeah, that's interesting. The patrons who cause great consternation because they refuse to use pronouns. That's difficult. And this question with the Elliott-Larsen Act right now is very squishy. We're not sure actually whether, what would fall under that. If you switched it to any other protected class, You know, it's still a little bit squishy because it's speech. And, you know, there's no law that says someone has to recognize someone's pronouns. Um, and, you know, it's kind of like the whole idea of hate speech. But whether it's you have, you know, patrons coming in who are deliberately treating employees differently, whether that's discrimination, that's one of those things that's still kind of unsure. I'm not sure. Now, if it were the employer doing it, that would be a different story. Or if it were other members of the staff treating the staff people differently, that could be a different story. But since it's members of the public and staff, that makes it much more difficult. So I have not seen anything yet on that piece of it. I'm still doing a lot of different research on the Elliott-Larsen Act and this idea of discrimination with, you know, the addition of LGBTQ and what the different situations are. But I think that because it's speech, I think that unfortunately there's not a whole lot you can do about it, because people are going to be mean, unfortunately, and that's just it's just, yeah, I don't know what to tell you. People just are being mean, and unfortunately, it's not against the law for people to be mean. Youth yelling at other youth, bullying other youth by touching. Yes, youth yelling and definitely touching is a behavior. As long as it's not what they say, if it's what they do. So yelling is an action. Touching is an action, and those are behaviors. So you can limit behaviors. You can have a you know, a no touching policy for, you know, minors. For you can have a you know, no raising your voice in the library. Again, you want to make sure it's very clear in what's considered, you know, raising your voice, because you'd also have to enforce things like loud laughter, or, you know, squeals of delight in the children's section. But, you know, I think that you could draft a policy that, you know, discusses, you know, actions of aggression, maybe against. I would talk to your attorney. I think there would be ways to phrase it so that you're dealing specifically with behavior, and not with words. Is there a retention period? Probably there are documents you would have to keep, you know, in the retention schedules. There are lists of, they kind of group them together, but there are like administrative documents and policies, and you have to keep those materials. Incident reports would be a library record, because a lot of, depending on the information that the incident report contains on it. So if you have someone's name and contact information who's a patron, that may be that may be counted as a library record, but it doesn't mean that you wouldn't retain them. It just means they wouldn't be FOIAble. But I'd have to look at the retention schedule to see exactly how long you would have to keep them. But yeah, I'm pretty sure that you would keep them along with your policies. Branded policies, if you need to print them. Yes, absolutely. I think that's a great idea, Grace, is to have policies that have your logo on them. I completely agree with that. I also think it helps is, like, say, for example, in the youth area, if you have issues with things like bullying, put your policy on the wall. You know, that, you know, however you want to phrase it, aggressive, or aggressive might be too subjective a word, but harassment, yelling. I'm trying to think of a good thing about touching it, because I'm not sure if you have like PDA rules, but you could say something like unwanted or unwelcome contact, and including yelling, touching, will not be tolerated and is a violation of library policy. So you could put something like that on the wall so that the young people are clearly notified that any type of behavior like this is not going to fly and you could get in trouble for it. Because notice is a huge thing. Thank you so much, everybody, for attending today. You will be getting some information, including that chart of specific statutes. And I'll be putting out more information as I get it. I know the defamation question is huge. It's something that I've been researching for a while. I know Answering also is keeping track of this across the country to see what other states are doing. Defamation towards our board members on social media or in a different municipalities meetings where we have no control. Again, this gets really difficult because some of this is really situational. Some of it depends on, again, because the board members are public officials, it's anytime you're a public official, the assumption is that people can say almost anything they want about you because you're in the public light. That's kind of the theory. So again, unless you can prove actual malice, it becomes very difficult to reduce. And certain social media platforms can have stricter requirements. So one thing that you could address there is if you have negative information, if a board member sees objectionable content about them on a social media platform, they could report that particular post to the social media platform. And in a lot of circumstances, the social media platform will bar it. And so that's one way individually the board members could deal with that. But from a legal perspective, it gets difficult. If it gets really egregious, I would talk to your attorney to see if there's anything they can find that they would be able to address via a letter or via contact with the entity that is supporting that. Okay, thank you, everybody. And more information on this as we get it. We will continue to update this. Thanks a lot, guys. We'll talk to you soon.